Hello guys, and welcome to another episode of my lecture. This is Olayeni Dieko Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode of Dieko Talks Law, we are talking about the law of equity, particularly the assignability and the history of choices in action. In my last class, I explained to you what choices in action is. I differentiated the different types of property as well as the different types of personal property and the different types of intangible properties that we have. Please make sure that you stop this video at this point if you have not watched the last video, to go to the playlist and make sure you watch the last video on what is choice in action before you continue this particular lecture. Also, if this is your first time of coming to my channel, I want to say a very big welcome to you. Please make sure that you click the subscribe button as well as the notification bell, so that anytime I release a video of this nature which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. Also, please make sure that you follow me on LinkedIn at Dieko Daniels and on Instagram at Dieko_Daniels. And I would also like to shout out to two particular people. The first person is Blessing Ernest, a Delta State University student in Nigeria, who helped type the notes and made the notes ready for this class, and also Odunwale Emmanuel, a University of Lagos student, who made sure that the graphics and everything needed for this lecture is made available. Thank you so much, guys. So now we talk about the crux of the class that we are having today. What is the substance of the class? We are talking about assignability and history of choices in action. Now, to the note, it says that at common law, the general rule was that unless the debtor agreed to it, a debt or other choice in action could not be assigned. Now, in my last class, I told you that when you are talking about legal choice, one of the first thing is what? Debt is an example of legal choice. What do I mean by debt? Debt in this context, somebody is owing you money, and let's say the person is owing you 1 million naira. Are you listening to me? And then you want to collect car from somebody, and you now say, okay, that is the person that is owing me money. Yeah, I am assigning the debt that the person is owing you. Let us say A, B, C. Me, I am B. A is the car dealer. C is the person that is owing me money. Are you listening to me? Now, when you are talking about A, B, C in this context, I went to meet A. Me, B, went to meet A. A, I have somebody owing me 1 million naira. 1 million naira cash, and I want to use that money to buy this car, but I don't have the money here, so I went to go and meet C. C, you see that car? I want to buy it. Therefore, you see that my 1 million, I have assigned it to A. Have you seen that? I have assigned that debt to A. Now, what we are talking, when we are saying assignability says that I am going to carry all my interest on something and give it to another person. The process of giving it to another person is called assigning it to someone else. Are you listening to me? So you see that my 1 million naira debt, I am going to assign it. I am B, I am telling C, I am assigning my 1 million naira debt to A. Give it to A. Now, at common law, the general rule was that unless the debtor agreed to it, that is, the person that is owing me, a debt or other choice in action could not be assigned. The person that is owing me, that is C, is the debtor. Except C, the person that is owing me, I'm the creditor. The person that is owing me, except he decides to agree that I can assign that 1 million naira that he's supposed to give me, I can assign it to A to collect a car from A, except C agrees, then you cannot assign that debt at common law. However, you should note that this is because choices in action were regarded not only as personal, but fear was also entertained that their assignment might encourage non-maintenance. Do you understand that? Now, the judges at the common law court saw choices in action as what? As personal. And because it was personal, when you begin to assign, for example, where B, that is me, I've assigned my choice, which is my debt, from C to who? To A. C, who knew that it was me that he was owing, not A, will not take it seriously to discharge. Do you understand that? C will say, me I no too know you like that, oh, shey you get, I no know you. A, you are a car seller, shey I come to your shop to come and buy car, I didn't come. Oh yeah, stay your own, I stay my own. The person I'm owing money is who? Is B. So C will say that since he wasn't the one who, borrowed money from A or had anything to do with A, it is none of C's business, so to say, in relation to the debt. And that's the reason why the common law judges said, there was fear that the assignment might encourage non-maintenance. However, the personal nature of chosen action no longer invalidates all assignments, but continue to do so, that is, invalidate assignment in respect of those which involve personal skills in confidence, or the assignment of which will prejudice the debtor. Now, what are we talking about here? You know that we have different choices in actions. So we are talking about share of a company, bill of exchange, we are talking about copyright. So in the common law court before, they do not like you transferring your right on a book to someone else, your right on a song to someone else, your share in a company to someone else, or your debts owed by somebody to you to someone else. Do you understand? They did not like that, and because they didn't like that, they stopped it. However, now, according to the case of GRIFFITH versus Tower Publishing Company, what we can see is that the rule has evolved. Now, the personal nature of chose in action no longer invalidates all assignments, which means that you can actually transfer chose in action, you can assign chose in action, but continue to do so. That means continue to invalidate assignment in respect of those that involve personal skills in confidence. Personal skills in confidence include something like, I have paid you to come and do the furnitures in my house. Now, the right that I have over you doing the furniture is a chose. Do you understand that? Is a chose in action. Come and do the furniture in my house. So now I paid you 500k to come and do the furniture in my house. But let's say something happened and I'm leaving Nigeria, and I don't want you to refund me back by 500k. I then assign that personal skill which I have a right to by virtue of me paying to you 500,000. I assign it to my friend. We both bought house the same time. He has not found someone to decorate his house, so I'm assigning it to him. I'm assigning my right to him that you should not come to my house to do it, but go to his house to do it. Do you understand what I'm saying? When you are talking about personal skill in confidence, we are talking about somebody's ability to do something. Now, I have paid you to do something for me. Do you understand? To, do the furniture in my house, to make the furniture, and I paid you 500,000 like I've said earlier. But something happened and I will not be able to, supervise or be in the house while you are doing it. Therefore, my friend who also built a house assigned my interest in that your skill to do the furnitures in my house. I have an interest in that skill. I have assigned it to who? To my friend, that he should be the one to receive it. The reason the common law court frowned at it is because of non-maintenance. Because he didn't do the contract with my friend, he might decide to do anyhow. Do you understand? I say, Shebi, I no kuku do contract with you, waiting to to consign me like that. Do you understand? So he would just decide to do the whole thing anyhow and then decide to leave. And because the contract was not with him, you cannot enforce anything against him. Do you understand that? Do you realize that? What you can only ask is, has there been an assignment? Yes, there has been an assignment. Did he do it? He did it. Whether or not he did it to the taste. Do you understand? For there to be a breach of contract, there must be an agreement. There was no direct agreement between the furniture maker and my friend. Therefore, can we say that there has been a breach well enough for him to want to enforce against? Do you understand? You don't have that. All you just have is an assignment from me to my friend. And that's the problem in the common law. So that is why the common law said, you know what? Okay, when it comes to other things, you can assign it. But when it comes to skill in confidence, or the assignment of which will prejudice the debtor, then you can assign those ones. And we can see in the case of GRIFFITH versus Tower Publishing Company. At common law, only legal choices were recognized, but equity from an early date gave effect to the assignment of both legal and equitable choices. An assignee of an equitable choice and still is allowed to sue in his name in equity to enforce the interest, but an assignee of a legal choice had to sue at common law in the name of the assignor, equity compelling the assignor to permit the use of his name. Now, I know that at this point you are already confused. He will only sue in his name, did not sue in his name, sue in the assignment. What is all this? Okay, let us take it step by step. Let's start with the first line. The first line says an assignee. Now, the first question, who is an assignee? Now, like I said, I am B, right? Somebody is owing me 1 million. Who is that somebody? C. And I want to get car from somebody, A. Therefore, I am the creditor. C is the debtor. I am the assignor. A is the assignee. Do you understand? I am the one assigning. I am therefore the assignor. Who did I assign that debt that C is owing me to? I assigned it to A. A is therefore the who? The assignee. Do you understand? So the receiver of the assigned chose is known as the assignee. The giver of the assigned chose is known as the assignor. Therefore, an assignee of an equitable chose, let us say that debt was equitable. Are you listening to me? Okay, we know it's legal, but let us say that whatever it is that I assigned from myself B to A is what? Is equitable. An assignment of an equitable chose over and is still allowed to sue in his name in equity. So if A wants to sue C to make sure that C gives him the 1 million naira for which I have collected a car, do you understand? A can sue in his own name if it is an equitable chose that has been assigned. Are you see why I said this thing was complicated in the first class? You need to understand certain intricacies, and those are the intricacies that we are talking about now. Now we started. When you are talking about choices in action, we have what? Legal and we have equitable. Abi? I gave you an example of legal, I gave you an example of equitable in my last class. Now we are taking it a step further. Now imagine that we have an equitable chose. Are you listening to me? An equitable chose has been assigned. If the owner of that equitable chose, who is the owner? The assignee, the person that I have given the chose to. Do you understand? The debt came from me to A. I am the assignor. A is the assignee. If A says that he wants to enforce his chose and he gets to court, on the paper, who is going to be versus C? Is it me, the initial owner of that chose, or is it A? Do you understand? If it's an equitable chose, A can use his name. So it's going to be A versus C if it's an equitable chose. That's what we are saying. Now let's go back to the note. An assignee of equitable chose, A, me I'm the assignor, A is the assignee, over and is still allowed to sue in his name in equity to enforce an interest, that 1 million naira from C. But an assignee of a legal chose, that is, let's say that now the whole debt thing was legal, not equitable. Now A is still the assignee, while B is the assignor. So an assignee of a legal chose or legal interest had to sue at common law in the name of the assignor. If the chose is legal, A cannot sue in his own name. He has to sue in B's name. That is my name. So if the chose is a legal chose, what you see is B and A versus C. If it's an equitable chose, you will see A versus C. Do you understand that? That equity compelling the assignor to permit the use of his name. But that was before. Now today, a legal or statutory assignee of a legal chose in action can sue in his name. That's today now. Before, he could not sue in his name. He must sue in the assignor's name. But now, a legal chose in action, assigned chose in action, can sue in his name. I'm talking about the assignee. Now, an equitable assignee of an equitable chose sues in his name, normal, unless the agreement isn't absolute. Now we are going to talk about that when we are talking about the elements and all that. Don't worry, let us not go into absoluteness. When we are talking about absolutely, let me just give you an expository. So now I am being owed 1 million, I be by C. Now that car is worth 500. Are you listening to that now? That car is worth 500. Therefore I am telling him to pay him 500 and still give me 500. So therefore the assignment is not absolute. The assignment is part. In equity, an equitable chose, you can sue in your name. That's the assignee. He can sue as A versus C, but where it is not absolute, he must put my name. Are you listening to me? Don't get it confused, don't get it complicated. In equity, you can sue in your name except it is not absolute. In legal, you can sue in your name, and in your name I'm talking about assignee. Assignee, you can sue in your name. So in equity, you can sue in your name except it's not absolute. Then you have to bring the assignor. But in legal, you can sue in your name whether or not it is absolute. Do you understand that? But an equitable assignee of a legal chose must join the assigner in the action, either as a co-plaintiff or as a co-defendant. In the case of Performers' Rights Act versus London Theatre of Varieties. Now you see, this is where we are now getting deeper. So you know the one that we're talking about, the choice is what is legal, or the choice is equitable. If the choice is legal, you sue in your name. If the choice is equitable, you sue in your name except it is absolute. Then you must join the assigner. Now we are now taking it a step further. If there is an equitable assignee of a legal choice, you know what we have been talking about is the choice itself. Is the choice legal or the choice equitable? We did not speak about where there is an equitable assignee of a legal choice or a legal assignee of an equitable choice. You see, now we are getting into another conflicting and confusing area. You see, this area is what I'm going to be discussing in my next class, where I'll be talking about classification of assignments of choices in action. There are 4 classifications, and I'll discuss each of those classifications in my next class. Please make sure that you stick to my next class where I'll be talking about these classifications. Thank you so much for watching to the end of my lecture. Please make sure that you subscribe, like, and share this video lecture with your friends, and also make sure that you follow me on LinkedIn at Dieko and on Instagram at Dieko_Daniels. I will see you in my next class.